Hey everyone, Chase Elleby and Joel Williams from Williams Elleby coming to you today with week 17 in our series of 52 weeks of personal injury. And today we're going to be talking to you about the question of whether or not an employer can be sued for the actions of its employee, which is basically the legal doctrine of Respondeat superior, which Joel in Latin translates to the master must answer. So a little fun fact for you there. So can the employer be sued by the conduct of its employee?
Yes.
And why?
The end.
Right, exactly.
No, yes, they can in most situations. The law is set up in a way that if the employee is on the job and working for his or her employer, at the time that they injure someone else, they can usually be sued. There are several examples for this. The most common one that comes to mind would be if an employee is driving somewhere.
Right.
For their job while they're on the clock at the direction of their employer, and they cause a car wreck and hurt somebody else, then the employer can be liable for the negligent acts of their insured.
Right.
I'm sure there's some other examples. Can you
Sure,
think of
yeah, and it typically has to be within the duty and scope of that employer-employee relationship, right? So it can't just be, if that driver's working for a company, but then they decide to, take a stop at a restaurant and go in and rob the place or something like that. That's way outside the scope of that employee's job, assuming they aren't a bank robber. But yeah, typically it has to be within that scope, right? Another example I like to give is, if you're at a restaurant and an employee comes and mops the floor and doesn't leave a sign out or something like that, and someone slips and falls, well, the restaurant or the employer, the owner of that restaurant is going to be responsible for that employee's conduct and creating a hazard and not warning others of that hazard.
Yeah, and it's funny because it's not just situations where an employee screws up and hurts somebody that the employer is just directly liable under that Respondeat superior doctrine. Mm-hmm. There are other situations where the employer can be liable on other legal theories, such
Right.
as negligent hiring or retention of an employee. So a good example of that would be like a tractor-trailer case where the tractor-trailer driver is employed by the trucking company, but the trucking company doesn't do a proper background check on that driver, and so they don't know that, okay, well, this driver's got 4 DUIs and 27 speeding tickets, and then they hire him and put him behind the wheel of a 80,000-pound fully loaded tractor-trailer driving on I-75 right through the middle of Atlanta, and guess what? He's drunk and he hurt somebody, right? They can be liable under Respondeat superior as well as under theories of negligent hiring and retention in that situation.
Right, exactly. The way I like to think of that is an employer has to be reasonable in hiring an employee for whatever position it is, right? So it makes sense that there has to be some sort of duty or obligation on the employer in your situation to, let's check to see this guy's driving record. Can he handle driving a tractor trailer? These people are on the roads thousands of miles a year. They got to be responsible and make sure that whoever they're hiring to drive those trucks are qualified. And if they're not, and we come to find out they cause a wreck and things like that, they can certainly be responsible as the employer and not just through that agency theory that we talked about. So yeah.
Yep. And that deals with the hiring, but also with the negligent retention. Mm-hmm. So, in our tractor trailer example, there may be a driver that's hired by the trucking company that has a crystal clear driving record, and they get on the road and they do fine for a while, and then for whatever reason something happens in their life and they get drunk and drive a tractor trailer while on the job. If they're not terminated and the trucking company keeps them and they continue to allow them to get on the road and drive, and then it happens again, then maybe the company can be liable for negligent retention of that employee.
Right.
So,
yeah, right. So if you knew that person couldn't drive because they messed up as one of your employees, then you shouldn't have let them drive again, right? So it's a pretty simple concept as well.
Yeah, that's right. And one of the main benefits from the injured party's perspective of being able to bring the employer in is that usually at that point you're going to be dealing with a commercial insurance policy, which in most cases provides more coverage than I would say the average amount of a personal policy,
right?
Because most businesses are going to purchase more liability coverage to protect themselves than individuals would. Right. I think that about wraps it up. There are some sticky situations where there are some defenses based upon whether somebody's actually a W-2 employee or a 1099. There's defenses like the borrowed servant doctrine. If you want to really nerd out, you can check out this video on the borrowed servant doctrine that I did a while back, and get your nerd on with that. But otherwise, that wraps it up for week 17. And if this video has been helpful to you, we would appreciate you subscribing to our page, giving us a thumbs up, or putting a comment in the section below. We'll see you next week for week number 18.